Every day in the USA, people find themselves in court.
Court does call the case of the people versus Christopher Day.
Good afternoon, Your Honor. Michael Doby for the people.
Good afternoon, Your Honor. Prosecution on behalf of Mr. Day is present to my right.
Your name?
Christopher D.
Hey, all right. All right. Date and time set for a preliminary examination. Are the parties ready to proceed?
We are, Your Honor.
All right. And I would just say that we had a in-chambers conference. There were some legal issues raised, and so the court may not finally rule on those today, but we'll take the testimony in the case. My understanding is that there's particularly an issue regarding the sheriff's department policies. I will take that testimony, and then this court can figure out if I ultimately determine that I cannot use it, then I won't. Additionally, if the court does determine that the policies won't be used as the basis for the misconduct, and I inform counsel of this, but can be used in order to, as some substantive evidence regarding the particulars of an element, particularly the corrupt nature of the actions, then the court may indeed take that testimony for that purpose. But so we can move this along. The court will hear the testimony and then make a decision later as to how it will be used.
Thank you, Your Honor.
All right.
With that, I would call Kurt Schifferkowski.
All right. Sir, please come forward and be sworn.
Raise your right hand. You solemnly swear to affirm the testimony about you to be the truth, the whole truth, and nothing but the truth, so help you God. Take your seat. State, spell your first and last name for the record.
Kurt Schifferkowski, K-U-R-T, last name S-C-H-I-A-V-P-A-C-A-S-S-E.
Thank you, sir. What do you do?
I'm manager at the Washington County Sheriff's Office.
And how long have you been in that position?
In that position since 2021.
Okay. And before that, what was your experience in law enforcement?
Started off at the Sheriff's Office in 2001. Was a corrections officer, was a field training officer, was a sergeant, no war, ran transport and port security, as a lieutenant, went through the police and corrections academies, went to the MSA, special investigations, did some work at the AG's office. And,
Thank you. I'm going to have some questions about incident in the jail, Washington County Jail, March 18th of 2024. Okay. Now, before I get to that, I suppose, do you know the defendant in this case, Christopher D?
Yes.
And how?
I'll stipulate the identification and that he's a law enforcement officer in the employ of Washington County Sheriff's Department.
All right. Very good.
Appreciate that.
So stipulated.
We'll move along. Thank you, Mr. Gucher. When did you become aware of the incident in question here?
there was an email notification that was made. At the time, D was a sergeant and he was working midnights, and I remember waking up and checking my emails the next day, and I saw an email notifying that there was a use of force in jail. Reviewed it, things stuck out to me.
Tell me about that.
What immediately stuck out was that the email indicated that Sergeant D sprayed a subject in the back seat of a police vehicle, an empty police vehicle, while she was in restraints.
Okay. That stuck out to you. What did you do?
Notified one of the lieutenants that we needed to evaluate the situation when I came to work.
Okay. And so why did that stick out to you?
So ASR spray is used when somebody is a threat, and because she was in restraints in the back of a police vehicle, bars over the window, I had concerns as to whether or not that person was a threat at the time of the incident.
Could you tell what is ASR?
Aerosol subject restraint, commonly known as MACE.
Okay. And is that something that is issued to officers in the jail?
It is, sir.
Okay. And are there trainings regarding that?
Yes, sir.
That are required?
Yes, sir.
And are there policies regarding that?
Yes, sir.
And are there what is done, if anything, to make sure that the officers know about the policies?
Anytime there's a policy revision or anytime there's a policy that's newly published, it's sent out in a program called Power DMS. The employees are required to review the policy and electronically sign. And yearly, there's also a constraint. There's a training course that's pushed through Power DMS where the students have to participate in the training, watch a video, and take a test.
Okay.
Successfully pass the test.
Specific to ASR.
Yes, sir.
Okay. Approach with people's proposed 4, 5, 6, and 7, which I've shown to Mr. Gucher. Thank you. May I approach, Your Honor?
You may.
Commander, I've handed you people's proposed 4, 5, 6, and 7. Can you identify what those documents are?
4 appears to be an excerpt from the subject control policy. 5 is a use of force concept paper on the use of force continuum. 6 is an excerpt from professional standards policy. And 7 is an appendix that shows the resistance and control between the suspect and staff member.
Okay. And are those all Washington County Sheriff's Office policies?
They are.
Okay. You're familiar with each of those?
Yes.
And is it true that you had a hand in writing some of the use of force policies?
In the use of force policy, but not the concept paper nor the professional conduct policy.
Okay. Your Honor, subject to your earlier ruling, I would move for the admission of people's 4, 5, 6, and 7.
Any voir dire or objection?
Just for clarification, those policies were in place as of the date of this incident, correct?
Yes.
No other objections other than the ones already noted by the court.
All right, very good.
Thank you.
4, 5, and 6. 4, 5, 6, and 7 are conditionally admitted.
Thank you. You mentioned that it's the incident that you were things stuck out to you because it was a use of ASR against someone who was handcuffed and in the back of a police car. Is that right?
Yes, sir.
And generally, from the what is your understanding from the policies of the proper use of ASR within the jail?
ASR isn't classified anywhere in the force continuum. It can be used anytime that the person that's applying force feels that lower forms of control will not be adequate.
Okay. Lower forms of control, what does that mean?
Muscling techniques, placing someone on the ground, escorting them.
Okay. Tell me about what you said, something about the individual not being a threat.
Yes.
Where does that fit in?
So ASR is used when there's a threat to staff or a threat to another person. And as the victim in the case was in restraints in the back of a police vehicle with bars out the window, it was difficult for me to see whether or not there was a threat to anybody else.
Okay. You talked about levels of clients using lower force to gain compliance. What does this mean, compliance?
To bring about a peaceful end to the situation, to bring about the lawful conclusion to an event.
Okay. When someone is, no, let's strike that. I'm not going to propose any hypotheticals there. Did you see, Commander, any justification for the use of ASR in that situation?
Objection relevant. Whether or not this officer sees that it's relevant is not the legal standard. Actually, under Graham v. Cards.
As to the form of the question, I'll sustain the objection. I'll allow you to rephrase the question, but I think as it's phrased, I think it's.
Thank you. In a situation like this, Commander Shipakasi, where someone is handcuffed and in the back of a vehicle. Is that based on both your understanding of the policies and your own training and experience, a situation where ASR would be necessary?
Based on my training and experience, what I saw, no,
Okay. And why is that?
because the person was not a threat at the time that ASR was used.
Okay. Talked about compliance. What was being asked of the arrestee at that point to comply with?
Answering questions as to whether or not she was suicidal.
Okay. What the 3 core questions that was referred to? What are the 3 core
You
questions?
have medical needs, you take medication, or any thoughts of hurting yourself.
Okay. And what is the purpose of asking those questions?
Just gauging whether or not they're going to be suitable to enter the jail to have the full medical evaluation done.
Okay. And if
Sorry, also gauge whether or not we can place that person on any kind of observation.
someone does not answer those questions, what is done?
It's not unusual. We bring them into the facility, search them, possibly place them on precautions depending on the situation.
Okay.
Cross-examinations.
Commander, briefly, were you going to get the individual out of the car?
I'm sorry, sir.
Were you going to get this individual question out of the car?
No, sir, I wasn't there.
Okay, so you weren't there, but you determined that there was no threat to the officers that were, correct?
Based on the circumstances.
Okay, were her feet restrained?
No,
What direction were her feet facing while the sergeant was talking to her?
I'm not sure.
Okay, well, if the feet were facing the officer, could that be a threat?
No, because she was in the back of
Okay,
the vehicle.
is that where she was going to be housed?
No,
Okay, so what do the officers have to do to house her?
move her from the vehicle.
Okay, so if they open the door and the feet are facing the officer and they're unrestrained, is that a threat?
No, that's typically how we get people out of the vehicle.
So you're telling me that it's not a problem for officers to be kicked?
No, I said that's how we usually get people out of the vehicle.
Right, but that wasn't my question. Is that a threat to have the feet unrestrained at an officer?
Depends on the circumstance.
Okay, so did you see the demeanor of the individual that was coming into the jail?
I did.
She was kicking the back of the windows of the car.
When she was on the way there, yes.
She was screaming, yelling, insultive, combative.
Yes, sir.
Okay. The officers have to make a determination to get her out of that car, right? How they're going to do it?
Yes, sir.
Now, the 3 questions were just a precursor to getting her out of the car, correct?
Yes, sir.
The officers were actually there to extricate her from the car and put her in a cell.
Yes, sir.
Okay. Sergeant D or Day and one other person, what was the other sergeant that was present? Do you recall?
We was Sergeant Merrick.
They're the ones that are in charge of getting this individual out of the car, correct?
Yes, sir.
The other sergeant was a female officer, is that correct?
No, sir.
No? Were there female officers present?
Yes, sir.
And that was in part because not only do they work in the jail and handle all other business, as a policy and procedure, you guys have female officers when available, deal with female.
When
Is
available.
that correct? And again, the ASR doesn't appear on the chart because you said that, and I want to get this quote right, not part of the continuum because it can be used anytime the officer feels or believes. And what was the
The
rest?
lower forms of control not be adequate.
Okay, no further questions.
All right, thank you. Any redirect?
One question, Commander Shipakasi, based on both the policies and your training and experience, is the preemptive use of ASR spray reasonable?
Given the circumstances, no.
Okay, thank you.
Yeah. You may step down. Thank you, Commander.
Oh, Brian Miller.
All right. Sir, please come forward to be sworn.
AC, raise your right hand. You solemnly swear to affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth. Brian Muller. Muller, M-I-L-L-E-R.
All right, you may inquire.
And what do you do, sir?
Currently, I'm a special investigator with the Washington County Sheriff's Office.
And how long have you been doing that?
Since 2009.
Okay. And briefly, you have law enforcement experience before that?
Yes, I've been a certified law enforcement officer since 1974.
Okay, thank you. I asked some questions about an incident in the Washtenaw County Jail on March 18th of 2024, okay? How did you become involved in that?
I received a phone call from Commander Shipakasi stating that there was an incident that took place on March 18th in the Sallyport Correctional Facility at approximately 20 feet, 30 hours, involving WCSO personnel and an arrestee from the Tulane Police Department.
Okay, and was that arrestee Rachel Dameron Hissong?
Correct.
Okay. So you got this notification from the commander. What did you do?
I was instructed that they had some concerns, they being the administration, of whether or not the use of force was appropriate in this particular case.
Okay.
And I was instructed to conduct a non-administrative investigation.
Criminal investigation.
Correct.
Okay. And did you do that?
Yes, I did.
Okay. And you could walk us through a little bit about the steps that you took in this investigation.
Well, one of the things I did was I had a liaison with the corrections division, a lieutenant that I asked to assist in some of the technical aspects of the investigative process by gleaning information from audio and video information that existed in a series of cameras. Initially, information from the Sallyport, then it was information from the body cams worn by Sergeant D and Sergeant Merritt, as well as information from the cameras in the holding cell, as well as information of the activity that took place.
Okay.
That was the first step.
Your Honor, I'll stipulate to the admission of I believe we discussed body cam of Sergeant Day and the in-car camera from the point in time it reaches the Sallyport at Washtenaw County Jail to the end of this incident, correct?
Yes.
Yes, stipulate.
All right.
Thank you. That will be People's Exhibits 1 and 2. I'll ask one question. Did you also receive any records from the jail?
Yes.
Okay. Approach with People's Pros Exhibit 3.
Yes.
No objection, Your Honor.
To the admission?
Yeah.
Okay, I move.
You want the mugshot of the individual?
Yes. Could you just identify what that is for our record, People's Exhibit 3?
States on the front page, it's a mugshot profile, and it says Rachel Marie Dameron Hissong, and it shows a picture of her front picture and a side profile. The second piece of paper says Washtenaw County booking report, and it's a copy of her booking report from the date in question.
Okay. Move for the admission of People's Exhibit 3.
And I heard there's no objection, so Exhibit 3.
Okay. Jumping back to where you were, Mr. Miller, you obtained a number of videos.
That's correct.
And People's Exhibit number 1, which has been admitted by stipulation, is going to be the body cam of the defendant. And if you will give me a moment to connect. And I'm going to begin playing at 23:32:44, the timestamp in this video.
You just cracked the window. Hey, Rachel. Hey, my name's Sergeant D. I'm the supervisor that's on shift right now, along with Sergeant Merritt, okay? Hey, so I want to get you in, but I want to work with you. I don't want to, I do. I want to work with you.
So let's just be honest.
So I get paid whether you're here or not. All right, so here's the thing. I want to get you in the door. And we are having a conversation right now. No, we're not doing that either. Are you suicidal? Are you suicidal? I'm asking questions. Are you suicidal?
Yes or no, are you going to respect?
I have been treating you.
Yes.
So,
Simple motherfucking question.
are you suicidal? Yes. Yes, I'm going to treat you with respect. Are you suicidal? Yes or no?
Answer my question.
Do you have any emergency medical needs?
Yes or no?
I have been. Rachel, I'm trying to help you out.
Yes. Answer yes or no.
So here's what I'm going to tell you.
Yes. Still not answering the question. Literally, all you have to do is answer.
I'm trying to get you taken care of, and I'm trying to work with you.
I'm asking you, are you going to treat me with
Do you have any meaning? I've already told you yes.
Yes.
This is the last time I'm telling you.
And I can treat you like
Never.
Shut up!
Right now. Stand up. Go down to your knees. Lay down your stuff.
I'm going to stop the play there. We're at 23:36 and 34 seconds on the timestamp of People's Exhibit 1, the Sergeant D's video. That was one of the videos that you obtained.
Yes, it was.
Okay. And reviewed.
Yes.
And what did you do after reviewing that video? Oops, I didn't mean to start playing again. I'm sorry. Commander let me start that over. That was a terrible question. Commander Shipakasi talked about things sticking out to him. What sticks out to you in that video?
Objection, Your Honor. Relevance at this point in time. The he did the investigation. His opinion of what the investigation shows is irrelevant.
Oh, overruled. Oh,
What sticks out to you?
Well, a number of things. And you talked about, as qualified by saying, one of the things I did in my career was a chief use of force instructor, as well as a ASR instructor. And so when I looked at the actions and the interactions involved in this interaction between Sergeant D and Ms. Hissom, I felt that it was problematic in terms of the actions taken by Sergeant D.
Okay, what do you mean problematic?
The use of ASR is for someone that's non-compliant. Okay, and what I mean by non-compliant is that you've given them a directive, told them something specifically to do, afford them a reasonable period of time to comply with that. Okay, and you also give them a warning that if they don't comply with that, that there will be consequences, and subsequent to that, the ASR will be deployed. What I saw here was none of that took place. There was no warning given. There was no directive given. In terms of a threat to Sergeant D or anyone else, she was confined in the backseat of a patrol car, handcuffed behind her back, in a particular patrol car that has cages all the way around. What I mean by all the way around, both the side windows between the passenger compartment and the rear window were all caged in. And when we talk about imminent threat, okay, she was not posing at that time. She did not exhibit any aggressive, threatening behaviors that would necessitate the use of the ASR, nor was a warning given to her deployed with two other police officers in the front seat of the car. That's what was problematic for me.
But you heard her yelling at the officer and insulting him, right? You said that she wasn't doing anything.
So when we talk about ASR, what we're talking about is you want to gain compliance. Okay. Well, you have to have a directive to gain compliance. Okay, asking questions is not the same as giving a directive as I want you to do this. I want you to do that. We are getting ready to open the door. I want you to step out of the vehicle. Okay, none of that was given.
Okay. Tell me a bit about ASR itself, and you've talked about when it is appropriate to use, but what is the effect of it?
Well, it's basically a combination of like CS gas agent, a chemical agent that creates an irritant. Okay, so it momentarily incapacitates a person that will afford you the opportunity to take control of a person, and you hope that they will comply based on the fact of this irritant that has been applied to them.
Okay. Pain, right? It causes pain?
Absolute pain compliance.
Okay. What are the other considerations around ASR and the use of ASR that you were a trainer in? What are the other considerations?
Which you actually deploy it. In this case, it was deployed inside the confines of a occupied police car. And I say occupied, above and beyond the subject, Ms. Hissom was occupied by two fellow police officers in this Atlanta Police Department. And again, what I found to be problematic is that there was no warning given, so that they were equally being sprayed as well as Ms. Hissom in the confines of the car.
You also obtained the video from inside the police car, is that right? And that has been admitted as people's Exhibit 2 by stipulation, and I'm going to move to that.
Community college, too hot shit. Oh, you're a community college, aren't you hot fucking shit? You're fucking pathetic. You're fucking pathetic. And fucking everything you asked for. That fucking cunts. Shut up! Nobody's fucking talking to you, whore! Nobody's fucking talking to you, whore! No! Nobody is fucking talking to you, whore! Nobody fucking talking to you! Are you fucking done? Are you fucking done talking? You arrogant piece of shit! You are nobody! Are you fucking done? Are you fucking done? I'm just fucking done, kid! Do we want to fucking yet? Listen yet, you fucking whore! Fat, disgusting, ignorant, uneducated piece of shit! Swear fuck! Shut the fuck up! I keep it that way. Fucking worthless, fucking white trash, trailer park. How do I always get arrested? Fucking white trash, trailer park, hillbilly ass, useless, uneducated motherfuckers. It's unbelievable to me. It just blows my mind. You never get arrested by anyone with a fucking brain. You fucking evil fucking piece of shit. This team has nothing better to do with your time. Fucking go home to your wife. Go home to your kids, you fucking worthless piece of shit. Go home to your family. Go catch a rapist. Go catch a murderer, you stupid fucking redneck piece of shit. Fucking worthless piece of trash.
I'm pausing here at 23, 32, and 58 seconds. Mr. Miller, we've just seen someone outside of the window here. Is this when officers from the jail approached the vehicle?
Yeah, shortly thereafter. This probably I think within the next 15 to 30 seconds, they approach the vehicle.
Okay, so up until this point, it has been the arrestee and the Ypsilanti police officers. Is that correct? Okay.
None of the WCSO personnel were privy to this behavior.
Okay.
Go catch a rapist! Go catch a murderer, you fucking useless pieces of shit! What a worthless piece of fucking trash.
My name's Sergeant D. I'm the supervisor that's on shift right now. I'm officer. Okay. Hey, so I want to get you in, and I want to work with you.
You don't want to work with anybody. You want to make money for your little organization, and you want to split that money with big rehab. So let's just be honest here. I'm a healthcare worker. You're a whatever the fuck you think it is. You are. Now, here's the thing. You're going to treat me with respect. That's the first thing. No, shut up. You're gonna treat me with respect and then we're gonna continue. Are you gonna treat me with respect? I'm asking you a question. Are you gonna treat me with respect? Yes or no, are you going to treat me with respect? Yes or no, it's a real simple motherfucking question. Are you gonna treat me with respect, yes or no? You can answer to your questions, you answer my question. Are you gonna treat me with respect? Are you going to treat me with respect, yes or no? This is a simple question, then you can easily answer yes or no, which is it?
So here's what I'm gonna tell you.
Yes, you're still not answering the question. Literally, all you have to do is answer. No. You're trying to be a cunt. I'm asking you, are you going to treat me with respect? Are you going to treat me like I'm a human? Yes or no? Will I be treated like a human? You son of a fucking whore! You son of a disgusting fucking whore! You son of a disgusting human! You let me go! No!
And stopping there at 23, 35, and 15 seconds on the timestamp of the video. At this point, I don't believe I have any other more questions for you. Mr. Gucher, are you going to want to use the video? Okay.
Cross-examination.
Special Investigator Miller, you're aware of the policies and procedures, at least in general terms of the jail as it relates to inmates who come into it, correct?
Yes.
And Central Dispatch will notify, that's why the officers come out to the Sally Port when individuals arrive, correct? In your jail?
Yes.
And in this case, during the course of your investigation, you did discern the Central Dispatch told the officers that there was an individual who was kicking the car and being combative, and they had arrived, correct?
Correct. Well, he actually called it in and stated that information.
Right. So while the officers may not have been present for the entire event of the lady in the video, they were aware she was not being cooperative and kicking and such, correct? Had been. And you had the booking photo go in, I think someone had mentioned or the video indicated she was there on FA.
Correct.
For the record, can you state what FA is?
Felonious assault.
Okay,
That was the original charge.
that was the original charge. I have no further questions. Thank you.
All right, any redirect?
No, thank you.
All right, you may shut down. Thank you, sir. Any additional witnesses for the people?
No, Your Honor.
All right, any witnesses for the defense?
No, Your Honor.
All right, we had a previous bench conference, and I'm not sure how council wants to do this. I could certainly hear the bind over motion now and then argument. Or would you like the opportunity to just submit positions that you have in writing to the court prior to the court making its ruling? Whichever way is more convenient for council.
I'll defer to Mr. Dobie.
I'm happy to argue this now.
All right, very good.
Your Honor, the facts are pretty simple in the case and are not really in dispute based on the cross-examination that happened. Rachel Dameron Hissong was arrested for an offense, brought into the jail by YPD, and was a jerk. She was yelling and making a scene in the back seat of the car, as we saw in the video when she first got to the Sally Port. But it's the behavior of the defendant that's a question here. And we saw him approach the car, attempt to ask several questions, give no commands, not asking her to do anything, and not being any type of threat from this person. So setting aside for a moment that this is a police officer and all of the responsibilities, duties, and trusts that are placed in him, this is a person who is handcuffed and within a cage in the back of the vehicle who has a weapon used on her, that weapon being the ASR spray. That is an assault. It is a felonious assault based on the type of weapon that the ASR has been can be found by a trier of fact. A jury can find that is a dangerous weapon and how it's used. It was sprayed directly into her eyes, obviously causing significant pain based on the video. And a jury could find that it meets definition of a dangerous weapon and that it could cause a serious injury. But he was a police officer. I'm sorry, not a police officer. He was a corrections officer at the time who did have, who was there acting under the color of his office, performing or supposed to be performing duties of taking this woman into the jail. And his behavior by spraying her in the face when she was no threat, when she was not refusing any orders, when she was just not answering questions that Commander Shipakasi says happens all the time, that people do not answer those 3 core questions. She's not answering the questions and she insults him and he sprays her in the face with the ASR. That is a wrongful act. Going through the elements of misconduct, he is a public officer. He meets that definition. That's by stipulation. He was there. He was working, acting under the color of his office. The only issue at this is the corrupt intent. And for that, we've had some testimony and admitted some exhibits, obviously subject to the court's later ruling on them regarding those duties and responsibilities that are placed on officers and the trust that is placed on them for the people that are put into in their custody. By flagrantly violating all of those, spraying someone who was handcuffed and in the back of a police car, goes to show that his corrupt intent. He knew that what he was doing was wrong. He knew that he was trained in it. He had to recertify in this every year. And it goes against that trust that we put in people in his position for the basic humane treatment of people that are put into our jail. All of the elements of each crime have been proven to the standard necessary for bind over, and I ask that you do so.
All right, just one question.
Yes, Your Honor.
Had this, say the door had been open, either side, doesn't matter. And the arrestee is now out of the vehicle and let's say is thrashing around, we wouldn't be here, I guess.
I'm not sure
and then the deployment of the ASR.
I'm not sure that's I mean, in your hypothetical, she is still handcuffed. She is still a restrained person and within the jail. Kicking and thrashing around, I think that that there might be an argument that the use of ASR or other force is necessary, but in this circumstance, there's 7 officers around that car. Someone kicking and thrashing around happens often, and they are not sprayed while they are restrained.
Got it. Okay.
Yeah, the standard preliminary exam is simply they have to produce evidence to the level of probable cause or evidence that probable cause to each element could be inferred from the evidence presented. In this case, you have 2 unique charges that by the circumstances present themselves here. First of all, my client, by stipulation and by fact, at that time was a law enforcement officer working as a law enforcement officer, which means by law, there's certain things present for consideration for this court that's not present in the normal course of an assault and battery case. Graham v. Connor is the standard by law. An officer is given greater latitude to use force in the course and conduct of his employment. In fact, that court says the law recognizes law enforcement officers are required to make split-second decisions of life and death, which cannot be judged through the 20/20 vision of hindsight from the vantage point of judges on the bench, or for that matter, other officers who would have done things differently as they're sitting in an office reviewing the actions of an officer the next day. Even the policies and procedures of the Washtenaw County Sheriff's Department, which prosecution entered into evidence in this case, indicates that the officer makes the determination. What Mr. Miller left out and was already admitted into evidence in the general rules is that the AR spray, while it says employees shall provide a warning prior to deploying a chemical agent, if doing so does not increase the risk to the employee or another person, which again leaves discretion to the officer involved. Commander Shipapakasi testified that the use of force in an AR spray does not fall on the continuum of force. It's left to the discretion of the officer to use based upon the facts and circumstances as they see them. So take all that into consideration. How does that apply to the first charge of assault with a dangerous weapon? First of all, there was no assault because his use of the tools that were given to him for compliance were lawful. That's what he's supposed to do. That is the purpose of the AR spray. No officers in that video were injured. The individual did not sustain any serious physical injury and was not subject to death. The individual was removed from the car and taken to a cell. If you look at the facts surrounding it, they're trying to create that there was some type of retaliation by Sergeant D. There was no retaliation. He was very patient with this individual. The decision not to issue a warning appears, based upon the video, to be more in line with extracting her from the car in a safe manner for both him and his officers, which was successful. There was no abuse of this prisoner. The prisoner's legs were not restrained. The prisoner's mouth was not restrained. Every day, this court and law enforcement deals with situations where officers are injured by individuals, as you just gave in your scenario, getting out of the car and starting to act in a manner in which officers could be subject to injury. In this case, he short-circuited. The individual was not there for a white-collar crime. She was there for a felonious assault. The officers were made aware she was being non-compliant, combative, and kicking in the car prior to them ever going out there. Her actions in refusing to answer created a situation where Officer D, under the law, made a reasonable determination to extract her in the safest manner possible, and it was successful. In order for him to be bound over for assault with a dangerous weapon, they would have to prove by at least a preponderant or a probable cause level that a dangerous weapon was used in this case. By court, the standard jury instruction, a dangerous weapon is any object that is used in a way that's likely to cause serious physical injury or death. There's no probable cause presented in this case to show that the use of that pepper spray in this mace in this case would have caused serious physical injury or death. The facts and circumstances that are predicate to find that it was a dangerous weapon, there's no probable cause. That can't be bound over as presented to this court. The court rule, the standard jury instruction continues to say some objects such as guns and bombs are dangerous because they are specifically designed to be dangerous. Other objects are designed for peaceful purposes, but may be used as dangerous weapons. The way an object is used or intended to be used is an assault determines whether or not it's a dangerous weapon. In this case, because this is not a standard delineated by statute dangerous weapon, the court first has to find probable cause based upon the facts of this case that this pepper spray was, in fact, at least to a level of probable cause, a dangerous weapon, which I don't believe is present. Now go to the misconduct in office. Again, based upon the facts, they can disagree with how Sergeant D did his job that day, but that's just second guessing. You know, there's no depravity shown here. There's no corrupt intent. There's no perversion. You know, the court rule, proposed court rule that was provided by the prosecution in this case, the word corrupt is defined as depraved, perverse, tainted. I mean, that's not there. Corrupt intent includes intentional, purposeful misbehavior related to requirements or duties. What's interesting is even with the policies and procedures and testimony, nothing was intentionally against the policies and procedures. Policies and procedures do not require a warning if the officer deems that it could put someone at more risk than they're in. And there's no prohibition on using the ASR spray. So they didn't even prove that there was anything for their purpose of showing corrupt that he didn't follow policies and procedures. They didn't even show that. And then if you take the facts of the case as presented, he used one burst of pepper spray that's issued to the officers to gain compliance and to ensure safety of the officers and the individuals. He did that to get her out of the car.
What was he gaining compliance to?
To get her out of the car. That was it. He wanted to get her out of the car in a manner in which she didn't fight with the officers and the officers weren't hurt, and it was successful.
As I look at it, how would I know she wasn't going to comply with that?
You wouldn't, but if the officers take her out and they're injured, then you're second guessing saying, why didn't you use the pepper spray to get her out? Because that's why you have it to distract her.
No. But I wouldn't
Judge,
be
I haven't-
second guessing, would I?
Yes, because that's why we're second guessing now.
No, I don't think we're second guessing. I mean, the issue becomes that he didn't ask her to get out of the vehicle.
He doesn't have to.
All right. He doesn't say, we're going to take you out of the vehicle.
But Judge,
Keep saying he doesn't have to.
Right.
Counsel, just because you say it doesn't make it true. What he does, what you're arguing to the court is that the officer, upon some assessment, can take some preemptive strike because he believes that something is going to happen that hasn't yet happened.
Well,
I'd like to see, there's a
Even the-
case law that gets me
the
there.
policies and procedures provide for that. They can use the level of force that they believe is necessary. It's left to the employee's discretion. And and it's enumerated in there. There's active resistance, passive resistance. There's, if an individual is combative physically, or if they're just refusing to comply. Now, in this case, you're saying that he should have said, hey, we're going to open the door and take you out. Well, she was at the jail. Well, I mean, you're not saying that specifically, but
No.
you're saying, why didn't he open the door and see what she would do? And if she opens the door and he kicks him in the knee and blows it out, we're saying, well, you don't know that would happen. It happens in the jail all the time, Judge. All the time.
Okay, but the thing is, that would mean that anybody who is in the back of the vehicle, an officer would be correct, or at least could properly, anybody coming in, whether they're screaming, yelling, doing anything, if they're in the back in all kinds of restraints, I can spray them or do something to them under the notion that something might happen when I open the door.
I think that may be correct. However, in this situation, he's charged with specific crimes. There are other crimes that they can be charged with theoretically that wouldn't be assault with a dangerous weapon, i.e. a weapon that could cause serious physical injury or death. That would be a simple assault and battery. And an individual can be charged with assault and battery without being charged with misconduct in office, because while it may rise to the level of an A and B, it doesn't rise to a level of depravity, perversion, or corrupt intent. There's levels to this. The reason we're here is this is a felony charge in which they have to have probable cause for the charges they issue. That doesn't mean that another charge may not be more appropriate. These charges are not appropriate. And that's what we're here on today. And yes, officers are given great latitude to do their job. That is the law. Graham v. Connor, 2020 hindsight is not the standard. Can't second guess what he did. In fact, the court says unless the use of force is arbitrary, the officer has discretion. This is reading from People v. Sure. The officer has discretion within reasonable limits to determine the amount of force which the circumstances require. And he's not guilty of wrong unless he arbitrarily abuses the power confided in him. It's one of the cases I gave the court. It's a quote from the court. These are special circumstances based upon the fact that the officers work for the public, and their job is not necessarily second guessed. Force is part of their job on a regular basis. The charges in this case are not appropriate. And as such, there's not probable cause to in the first case.
Well, okay, whether or not the actions meet that what's charged,
Correct.
I guess I'm asking from a factual standpoint. What you're arguing is that anybody brought into the jail, doesn't matter what they're doing. You're saying that the court, if an officer responds the way that the defendant in this case has to somebody in the back of a vehicle, regardless of what they're doing,
No, Your Honor.
that they're provided that latitude.
No, Your Honor.
Okay,
What
you
I'm saying
explaining
is,
that?
as long as their actions aren't arbitrary. If you just decide that an individual sitting in the car is brought in, I'm going to spray him, that's an arbitrary use of force. But that's still not necessarily a felonious assault, and it still might not be misconduct in office. It may be a policy violation. Not every action is a criminal violation, Your Honor. And the officer, under the law, as long as his actions are not arbitrary, then yes, it's legal. That doesn't mean that it's not excessive. That's called a civil action. 1983 action. There's a whole list of things that officers aren't allowed to do that still aren't criminal, but they're charged in civil court all the time with violations. Officers are given special treatment. And as long as his actions weren't arbitrary, if there's a reason for it.
Yeah, counsel, I get that they're given special treatment. I know the law in that area. I guess my question is, that's not sort of carte blanche.
It's not.
And so the question becomes, in this case,
Mhm.
where are you drawing the line? Because the only reason we're here is one side's drawing the line here and one side's drawing the line here.
But
And I'm
that'd be a
trying to figure
factual
out
issue,
where-
which I don't want.
I'm trying to figure out where your line is.
My line on the first one is, it's not a dangerous weapon.
Okay.
Okay, so therefore that charge shouldn't be bound over. On the second one, it's not corrupt intent. There was no perversion. There was no depravity. If you're using the policies to say that there was corrupt intent or depravity, the policies say it's up to the officer's discretion that they can use the ASR. They don't have to give a warning as long as, there's
If the
certain things.
court would determine that a reasonable fact finder could conclude that it was an abuse of their discretion, does that then give rise to the potential that?
I would say no, because then you're basing the decision to bind him over on the policies and procedures and not the action. See, this is the dilemma that we talked about. Yeah.
You're not, that's not true. What you're saying is
Mhm.
that the discretion of, it's really the discretion of the officer. That's what the policy is.
Mhm.
I'm saying if one were to determine that it's an abuse of discretion, that equates to that depravity that we're talking about, or some corruption because it's an abuse of discretion.
No, that would
Wouldn't
mean,
that be for the fact finder to determine?
I think you're mixing, in my opinion, Your Honor, I think you're mixing two different concepts together to get.
No, I think you are in trying to run me in a circle, because what I'm saying is if I take the policy
Correct.
and I take that policy and I say, yes, they have discretion,
Correct.
but a reasonable fact finder could conclude that this is an abuse of discretion, which could be used as a factor to determine whether or not there's depravity or corrupt behavior.
Well, Your Honor,
That then,
I'll leave it.
go ahead.
You to go and make your own determination. I'm not going to be able to change your mind necessarily on that. I think we're going kind of in circles. But I will direct you to the People v. Milton case, which is the assault and battery and the misconduct in office charge, which kind of started this whole thing in 2003. And in it, it kind of addresses your first part that you're kind of coming at me with this question. And it said that if our holding will strike fear in the hearts of police officers throughout the state, that no public officer under the color of his office will feel entitled to behave in the egregious manner that this defendant did, it would achieve that result. So that it's saying to us that if our concern is that officers, when every time they use force, is going to be left to a jury to decide if that force was arbitrary and whether or not it's misconduct in office, the court says to the first part, if it's like this case, if it's horrible like this, what Milton did, then that's going to serve our purpose. But they go on at the end of that paragraph and says, listen, the defendants fear that in light of this result, any malfeasance on the part of officers will be construed to misconduct in office is unfounded. Only malfeasance committed during the existence of a duty under the office or under the color of the office and results from corrupt behavior constitutes misconduct in office. And I think in this case, if you look at that, there was no corrupt behavior on the part of Sergeant.
That was one of the cases that you presented to the court. Okay.
This isn't corrupt behavior. Milton, he beat the inmate. He hit him repeatedly, knocked him down, slapped him, hit him. This was an individual where the court, the witnesses, the prosecutor, they may all disagree and say you should have done it differently. But there's different levels to this. This is a criminal court with specific elements. There's administrative proceedings, civil proceedings, and other proceedings which you can address perceived wrongdoings. This is a criminal in which an individual's liberty is at stake. and they have to have probable cause to each element. I'm not asking the court to condone his conduct. You may disagree with what he did, but I'm asking you to find and hold them to the probable cause level of each element in this offense. Thank you, Your Honor.
All right, thank you. Mr. Dobie, anything?
Yes, briefly, Your Honor. First, I would ask that the court not place any reliance on the Graham case that was cited in the standard set there, because that is not applicable to criminal law in the state of Michigan. It is applicable in civil cases, but not in criminal cases.
Well, I use that jury instruction repeatedly. It is adopted by the state of Michigan. It is the use of force, and I have standard jury instructions that your office provided me, in which quotes that standard.
And as we go on, without belaboring the policies too much, I will just go on to the next paragraph of the policy that's cited. ASR can be used to subdue an unarmed attacker or to overcome resistance that is otherwise likely to result in injury or either the subject or the employee. ASR devices shall not be brandished as a form of intimidation. That is the policy on ASR. That is what he's trained. That is what he is supposed to be doing here. And that is absolutely not what happened in this case. It was malfeasance. It was, the intent was corrupt. The committee on model jury instruction says to look at People versus Kotu for the definitions of that. A tainted or perverse use of the powers and privileges granted to him. Tainted means a trace of something bad or offensive. Perverted means misguided, distorted, misinterpreted, turned from what is considered right or true. We expect that officers will exercise their duties in a manner that is fair and equitable. Doing the opposite of that is what is meant by corrupt intent in a misconduct in office case.
All right. Counsel, I want to make sure I take a look at everything that you presented to me, and I will give you another date to come back. I know my schedule's kind of tight this month, but I can do any Thursday in the afternoon. Would April 3rd work?
Yes.
It would, okay. So what I'll do is I'll turn this out, preliminary examination for April 3rd. It's my PCC day. I have no idea right now what it looks like. I'll just put it at 3 p.m. if that works for everyone. All right. All right, defendant's bond will continue. Counsel, did you get a copy of the order? I did.
I asked the court.
I didn't.
Okay. Yes, I signed it. So,
Signed.
yes, I'll give the parties, there's a copy for each of the parties. And, you know, I haven't rendered a decision on this, but I want to compliment both counsel for shortcutting the issues, getting right to the point. And actually, people should probably watch. I'd love to have younger attorneys watch the two of you and how you operate with respect to each other in a case. And I mean that from the bottom. Thank you.
Just one question, does the court
Yes.
want to retain the?
Yes, I need the exhibits. Yes, I need the exhibits.
Judge, do you want to just verify what's, I've got 1 and 2 on here, the full videos, okay.
All right. So if I have that, you're gonna get those.
May I approach?
Yes,
There's 1, 7.
and 1 and 2 of them. Got it.
Yeah, they're on there, and everything that we do has to be encrypted, so the password is right down there.
Got it. Okay. Understood. Okay. I think I put my date in. Yes, I did. Okay. And then, Mr. Wonders, I'm going to take a brief recess and come back and with our last matter.